Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today we will discuss about the determination of working condition, which is the Article 4 of the Korean labor law. So, Labor Attorney Jung Bong-soo, could you explain to us about this particular article and why is it so important under the Korean labor law?
Okay, thank you. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Yes, thank you for asking. That is very important. Determination of working condition. According to Article 4 of the Labor Standards Act, it stipulates that working condition shall be decided by mutual agreement on equal footing between employer and employee. The reason is it's a contract, but it's employment contract. We call employment contract or labor contract. So employer and employee made, but based on their free willpower, and they agreed about the working conditions. Also, usually employee have a superior power, while employee has a very weaker power, because employee's perspective, they need to get a job or make money continuously there, so they cannot have their own voice while they make employment contract. So labor law provide some what is how the working condition shall be decided by the mutual agreement between employer and employee on equal footing. I think that is basic concept for employment contract. Also, at the same time, it applies to the collective contract, like rules of employment. So when employer make rules of employment, then it is possible they make their own rules of employment. But if they change the rule disadvantageously, then they have to obtain collective agreement from majority of employees or employee representative. So employee representative means they are selected by majority vote of those applicable workers. So employee representative plays a very important role in making decision about working condition, like collective working condition, like introduction of working hour system, like flexible or selective working hours. Also, when they have some replacement off day, like there is Monday is working day, but Tuesday is off day, then by mutual agreement between employer and employee representative, then they take Monday as off days, maybe by means of using the annual leave collectively. So they are all needed to have a collective agreement with the employee representative or majority of workers. So the reason is this Article 4 of the Labor Standards Act, like working condition shall be decided by mutual agreement. So this concept applies to collective agreement. Also, employee cannot change their rule disadvantageously without obtain from those related workers. Yeah.
I see. So, could you explain? This is you explain about the particular article of this Korean labor law, but I understand that Gangnam Labor Law Firm has experience in many cases settling the dispute of the collective agreement.
Mm-hmm.
So could you explain about a particular case which is related to this article?
Yeah, of course. Yeah, there are some articles like this is Korean, like this company was still is very famous. It's Wall Street Journal Korean branch. So sales manager of working in this company, he had worked for this company for 10 years. Then so when he joined this Wall Street Journal Korea, the company promised to pay 2 times more than legal standard statutory severance pay. So when he resigned after serving 10 years, he thought he would be compensated like with this better severance rules, like 2 months salary for each service year. So he expected, but company just paid based on the severance pay by the Labor Standard Act. So he thought he could receive one time more for his severance pay. So he visited this labor law firm. So I interviewed this client and how the company changed their company's regulation, like rules of employment. So he told me without his recognition or agreement, they changed unilaterally. So but it has passed for several years, but he didn't complain because he didn't think he would resign. So but now he think that the company's unilateral change of working condition disadvantageously could not be available by law. So that's why he's visiting and asking for legal representation. Yeah.
I see. And you are also currently involved in the restructuring of one large shipping company.
Yeah.
So could you explain an example again, please?
It's possible personnel restructuring is available when company have a certain set requirement, like there should be urgent necessary for reduce like labor forces. So company has some financial problem or long time deficit, then it is possible. But in this case, employer should inform their schedule for some disciplinary dismissal. So company need to have a cooperation with the employee representative or union chairman. So without the agreement with the employee representative, company's decision to fire the particular person it become unfair termination. So collective agreement is very necessary in Korean labor law. So basically this comes from this article 4, the determination of working condition. Yeah.
I see. So I hope that this audience of this videotape can understand about exactly about this labor laws Article 4, so that they can utilize properly in their own company's rules and regulation. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.